Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about Métis children being adopted. Cases that should have gone to the Supreme Court of Canada, but didn't. Two Métis children were placed into the foster care system. In 2018, the foster care system applied for a permanent placement for the children. As a result of that application, the court had to consider whether or not the children were Métis and whether or not special consideration should be given to a placement with a Métis family. Ultimately, the court ruled that the children were not Métis and therefore did not have to be placed with a Métis family or given special consideration for such placement. This determination was later found to be an error, but the court determined that the error didn't actually impact the ultimate decision made by the judge about where the children would be placed, because in other factors of the original judge's decision, he had considered the children's Métis heritage. The judge had ultimately ordered that the children would be placed in permanent extended care with no access to their mother, and that she would only be given photograph visitation over the rest of their children's lives. This obviously was a very concerning issue, and it's obviously a very concerning issue for the Métis community at large. For a judge to make a determination that a person is not Métis in the course of a hearing, and then to have that determination overturned as an error, only for the children to be told in the review of the judge's decision that it didn't really matter because the judge considered their Métis heritage in determining what an appropriate placement would be, doesn't make a lot of sense. This obviously raises significant concern for the treatment of Métis children in the foster care system, and the treatment of Indigenous children writ large. For a court to say, you're Indigenous and therefore I find that you're entitled to these particular considerations, or you're not Indigenous, I find that you're not entitled to these particular considerations, but I'm going to consider your claimed Indigenous heritage in making my ultimate determination, is kind of a little bit contradictory. If a person is not Métis or not Indigenous, then the special considerations that they're supposed to have aren't applied, even if their Métis heritage is supposedly taken into account in other factors in the decision. If a judge is wrong in determining the very core of somebody's biographical identity, their culture, their heritage, their history, then obviously that should be revisited. And this was a great opportunity for the Supreme Court of Canada to do right by the Indigenous community, who is disproportionately impacted by the apprehension of children and the placing of children into the foster care and the youth system. This was a significant issue, and the Supreme Court of Canada ought to have seen the inherent contradiction here that has the potential to negatively impact Métis and other Indigenous children across Canada for years to come. It's disappointing that a court can really overlook the need to consider in an important and balanced way at every stage of a decision-making process the Indigenous heritage of a child that is placed into the youth care system. Hopefully the Supreme Court of Canada gets another opportunity to revisit this issue and makes the right decision about hearing a case and emphasizing the importance of these types of cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.